And I'm very happy to introduce this panel which I'm chairing on consent to medical treatment. We have two Rosies on the panel, which is rather nice, and one Liz. Rosie Harding is a professor at the University of Birmingham, has done wonderful work on ageing, various aspects of ageing, and has I think a groundbreaking work coming out, hopefully at the end of this year, on dementia and relationality and care. And I think that's going to be a really, really interesting contribution. Our second Rosie is, among many other things, a published poet. She's had 5 collections of poetry, 6 collections, Rosie, is it? Sorry, I think I misread. 6 collections of poetry, and she's also been very active in higher education for many, many years. And Liz, who you've met already, has been very active. She's very active in this project. She's a PhD in sociology in respect of service user involvement, and has been very active both with Amnesty International and with the REE campaign. So I'm very delighted to introduce them to you, and I'll hand over now to the first of our Rosies, Rosy Harding.
Thank you very much. And Mary is really going to have to keep me to time because I have a rather strange tendency to waffle on, so I apologise. First of all, I'd like to thank the Voices team for inviting me to come along today. I'm really delighted to be here and to be part of, even in a very small way, such an exciting project. I think it's fantastic work, and I really look forward to seeing what comes out of it. Unfortunately, what they've asked me to do is provide an accessible, critical introduction to the law of consent to medical treatment in a time limit of 10 minutes. This takes me 2 hours in lectures, usually. So, Mary will have to keep me to time. My plan for the next few minutes is to try and get through as much of this as I possibly can, to give you a whistle-stop tour of some of the main issues in consent to medical treatment. But I will have to leave some things out, and I'm sorry about that, but I also hope you won't be too annoyed when I don't go into depth and I just say things. So let's start with the general rule. Medical treatment can only be given when the patient consents to it. That is the general rule in law about consent to medical treatment. And if only we could just stop there. But that's the rule. Without consent, medical treatment would be a common law offence. It would be either the tort of battery or the crime of assault. So we need consent in order to avoid a crime or a tort. Even if there's no significant harm made, the tort of trespass to the person is still a civil harm. Even if the person is not hurt, it's still a harm, and that's important. So legally, this is why we need consent. But unfortunately in law, general rules don't tend to get us very far. We do tend to have lots of complexities and things for lawyers to argue about. So let's get on to some of the issues that we end up having to argue about. The first complexity comes, of course, in, for example, in emergency situations. Say there's a road traffic accident, the patient's unconscious, you need to, they're taken to an accident in an emergency department, and they need treatment to save their lives. Doctors can do that under the defence of necessity. It's not a tort, it's not a crime, and that's appropriate. But that is limited. It only goes so far as the treatment that's necessary to save their lives. They can't do other things that are convenient to do at the same time. If they notice something else is wrong, it's not necessary, it shouldn't be done then. They have to wait and gain consent. The second complexity comes when we think a bit more about what we mean by consent and what consent includes and entails. So how much information does a patient need in order to consent? And who can give consent? Well, in terms of the amount of information that's required, that's a standard that's sort of changed over time. And in the US, for example, they have a much more broadly developed understanding of what we would call informed consent than we do in English law. In English law, it's about consent to this general information about the risks involved. Back in 1985, in a case called Sidaway, Mrs. Sidaway was not informed of a small risk of harm during the surgical procedure, with a 1 to 2% risk of damage to her spinal column. She wasn't informed about it. She had the operation, the risk materialised, and she was seriously harmed and disabled as a result. She sued, and the House of Lords in that case found that there was no negligence, as at that point in time, the doctor's views of what treatment was best or most appropriate was generally followed. In contrast, in a remarkably similar case in 2004, Chester and Afshar, the House of Lords seemed to move things on a little bit, and Lord Stein went so far as to say, and I'm quoting, "In modern law, medical paternalism no longer rules, and a patient has a prima facie right to be informed by a surgeon of a small but well-established risk of serious injury as a result of surgery." So, lawful consent to treatment requires that a patient is informed of the risks of the proposed treatment as well as the possible benefits. And the key message is that consent is required for medical treatment to be lawful. The days when people could be unquestioningly treated in the way that their doctor thinks best are in the past, and that's where they should remain, and hopefully those remaining areas where people are treated without consent, for example in compulsory mental health treatment, will very soon be in the past. And certainly, hopefully, this project will help to move things forward in England, in Ireland, and in other European countries to that extent. So let's turn now to what we understand by the patient and who is legally allowed to give consent. Adults over the age of 18 are allowed to give consent. And 16 and 17-year-olds also have the right to give consent to medical treatment. They're not always given the right to refuse medical treatment. And that's one of these shades of grey and complexities that are involved in the law here. Under 16s sometimes can give consent to medical treatment, often are not given the right to refuse medical treatment. And that sort of issue of where people are given the right to consent to medical treatment but not to refuse medical treatment then tends to move on into the realm of adults with intellectual disabilities, cognitive impairments and psychosocial disabilities as well, which doesn't seem to be on my slide. Sorry. In those situations where people are found or held or decided by the law, by legal rules, not to be allowed to give consent, somebody else then steps in to give consent sometimes on their behalf. So for children under the age of 16, that would usually be their parent or guardian. For adults, it might be a person with power of attorney or an assisted decision maker or a co-decision maker under your new legislation that I'm afraid I don't really understand. But it'd be interesting to see how it comes about in practice, how co-decision making happens when the new Irish law comes into force. And when it's not parent or guardian, there's no power of attorney, it might be a court that makes that decision about treatment, and the court has the power to do that. I think I've used up a bit too much of my time already. So when we're consenting, what does it mean? How do we consent? What's required? Well, as has been mentioned a couple of times today already, a functional test is used both in England and under the new Irish legislation as well. And the functional test of what you need to be able to do in order to consent is set out in these three principles essentially around capacity. They need to understand and retain information relevant to the decision for the length of time it takes to make that decision only, to use and weigh the information that you have, balancing the risks and benefits of the particular decision, and then to communicate that decision. And that's the functional approach. What happens if someone can't under that functional approach? Then we default to those other decision makers that I was talking about a moment ago. So this was the common law test. It's also the test in the Mental Capacity Act, and it's the test that's been in not so many words, but into your new legislation here, the Assisted Decision Making Capacity Act in Ireland. Consent also has to be voluntarily given. If consent is in fact coerced, and I'm sure we'll talk more about voluntariness and consent in the next section, then it's not freely given. And if consent is not freely given, it is not legally valid. Of course, this is difficult too, because the line between persuasion, which is perfectly fine in legal terms, and undue influence or coercion can be a very difficult one to draw. It can be hard to see where things are. And this is why law is never straightforward. Why do we have consent to medical treatment? Why do we need consent? Well, we need it in order to protect two key rights that we have. The right to personal autonomy, which is protected under the Convention on the Rights of People with Disabilities, under Article 3A, respect for the inherent dignity, individual autonomy, including the freedom to make one's own choices and independence of persons, and the right to integrity. And in the CRPD, that's under Article 7, that every person with disabilities has a right to respect for his or her physical and mental integrity on an equal basis with others. So these are the two concepts that underpin why we need to consent to medical treatment, why it doesn't happen without our consent. Unfortunately, consent to medical treatment is rarely where the problems come. The problems tend to come when we're refusing medical treatment. Because if we are told by our doctor, this is what I think needs to happen, this is how I think we should treat you, and we say, okay, they'll just take that as a valid consent. It's when our doctors say, this is what I think needs to happen, and you say, no, I don't want you to do that to me. That's when we're held to a higher standard of rationality or decision making around consent. So for example, I have a partially impacted wisdom tooth. It's fine, it doesn't cause me any pain, but my dentist referred me to the hospital, and the hospital doctor took some x-rays and they said, it will decay, it will cause you pain, it will cause you problems, I want to extract it under general anaesthetic. And I said, no, you're not going to do that, I don't want you to do that, it's fine. And my reasons are, I'm an enthusiastic amateur trumpet player, there is a risk to damage to the nerve that controls my bottom lip, which is highly trained. So that risk was a risk that was too high for me to take. But I didn't tell the doctor that, I just said no. But I could have told the doctor that, I suppose. But I could have just said no because I'm a little bit scared about general anaesthetic. Or I'm a little bit scared about dentists. Because I am, as well. So, you know, these questions about the difficult cases about refusing are where the law of consent becomes difficult, it becomes hard, it becomes the things that we need to give more information about. Now in the courts and in law it doesn't tend to be normal dentistry that comes up, but more the really difficult decisions. Decisions about life and death, decisions about refusing blood transfusions or cesarean sections or force-feeding and eating disorder cases. These are the hard decisions that courts have to make decisions about. And unfortunately, what tends to happen is that when it's these hard decisions, the question of capacity becomes conflated with the question of the right to make an unwise decision or the right to say no. And that's when we need to think more carefully about what we do, about how we make these arguments, and about how we disentangle this question of consent and capacity from the right to make an unwise decision. And I've been told 3 times now to stop by Mary and by this chap in front of me. So I am going to stop there, but I'm sure we'll have time for some questions.
It's brilliant. Thank you very much, Rosie. I'm getting up to take her away in case she won't leave. We could have listened to you all day, but unfortunately time didn't permit. So we now have our second Rosie, Rosy Wilson, and we're very much looking forward to this. Thank you, Rosie.
Thank you for inviting me to speak, and thanks to all participants for a very interesting day from all over the world. It's been very, very inspirational. Voices is a great name. Most of us don't have power or status or money, but we all have a voice, and we have a kind of responsibility to use it, even if one's not always comfortable, because we don't always like telling people about the occasions we've gone mad, which is, I think, what I've been asked to do. I've no expertise in mental health studies. Although always an anxious person, I became a so-called service user when I suffered a breakdown in 2001 and another severe depression in 2007, both in my 60s when I had retired from paid work and returned to live in Ireland where I grew up. I use the word breakdown because that's how it felt to me. I also believed I was the most evil person in the world, that I'd destroyed my children's lives, and my sister tells me I said I'd caused the war in Iraq, though, like so many, I had been on the streets protesting it. I actually believe the often quoted adage, we do not break down because we are weak, we break down because we are too strong for too long. So my story, more or less, I lived a very demanding 40 years in London, bringing up 4 children while working full-time in education, mainly with groups disadvantaged in their initial education. The last 10 years as Access Development Officer for the London Open College Network. And We worked across all the university colleges, colleges of further education, community and adult education centres in Greater London. It was kind of staff and curriculum development job where we helped tutors to prepare their access courses and other courses for accreditation and validation as a route more suitable for adults returning to education to go on to university than the traditional A-levels. It was a route taken by thousands of mature students in London during the years during those 10 years. In 2000, I retired to Ireland where I'd grown up and done my degree. It was a great shock to me and my family when I had a breakdown at the end of 2001 and was committed to hospital, where I received 8 sessions of ECT. I was out of it, obviously thinking, of course, the war in Iraq. My sister and husband were advised that this was the best form of treatment for what was diagnosed as deep depression with psychotic symptoms. I believe the psychiatrist who treated me believed this was in my best interests and resulted in my apparent speedy recovery. However, memory loss, continued anxiety and 6 years medication led me to have another episode in 2007. This time I was admitted as a voluntary, in inverted commas, patient, but it was clear to me that if I had not agreed, I would have been committed. Once there, my clothes were removed for the first 10 days. I had no control over my drug regime. We queued up and nurses made sure that we swallowed the pills, nor of my food intake. The distinction between voluntary or involuntary patient is minimal. I think as other people here probably also realised. I have little memory of my first day due to the effects of ECT, but I did write a poem near the time, which I'm going to read, because I think it gives more of the experience than just talking about it. So this is just called ECT. Men in white coats bend over her trolley. Are your teeth false or are they all their own? They're mostly proud, she says. Her only memory of a month in there, 8 sessions under anaesthetic, a section patient. Believe us, you were very ill. Electric currents have switched your brain towards normal. Take your pills, come to the clinic. But she needs to scrape up snatches of events, half-remembered words like helicopter, dehydration. Her sister showed her a photo taken in hospital after she fell and her nose was broken. 2 black eyes stare from hollows. When she wakes up, she can no longer reach underground caverns where fears and dreams linger among stalactites. Currents wash them away, along with months of memories, leaving a cavity she may not peer into, nor fall down there again. I'm an active member of Amnesty International, and our brave group partook in Amnesty's mental health campaign, which they led from 2003 to 2013. They got 10 years of funding, which was very unusual, to try and work on and improve and generally campaign on mental health service. In 2012, Amnesty invited me to take part in a citizen jury where 14 experts by experience teased out many aspects of the mental health service measured against the United Nations Convention for Rights of People with Disabilities, which we had brilliantly expounded to us in our first talk this morning, with inputs from, for example, the Chair of the Mental Health Commission, human rights lawyers. It was facilitated by Amnesty staff for 4 days. The findings subsequently published by Amnesty and launched by the Chair of the Justice of the, and Equality Door Committee. I was then a member of the EEAG, where I met Liz first and John and a few other people. That was Experts by Experience Advisory Group, also run by Amnesty. And now of Recovery Experts by Experience, which is, we kind of try and continue the work. My poem, Even the Kindest Doctor is Fearful, was published in front of our Amnesty Citizens Jury report. I wrote it because I believe that we are all, including our doctors, afraid of our own so-called mental illness. We keep it at arm's and this can affect any one of us at any time. The doctors, in my experience, seem to keep it at arm's length. It's kind of a stigma which can be limited to those who have already been diagnosed, and other people don't want to know about it as far as possible. And so this was the poem that went into that report, and it's called "Even the Kindest Doctor is Fearful." Even the kindest doctor is fearful when his patient goes mad, tears grey hair, knows she's all bad, lets her family starve, fires the first shots of the war in Iraq. Her mind, dive-bombed by swallows, is all over dark. A white labrador barks. A playful dolphin is damaged by hammerhead sharks. Her doctor dares not explore snake-infested places, overgrown gardens, at the root of such ravings, where he may uncover more, even touch his own weeds, tarantula spiders hidden under wallflowers, where bumblebees hum on his tidy, cultivated borders. With a solid desk between them, not reaching to touch in case it is catching, he diagnoses faulty brain chemistry, late onset in her 60s, genetic. He invites her to stay in his hospital on the coast where they'll mind her, cure her with currants for the brain, drugs for bad moods. When she resists, he commits her. 10 years after, although she's as docile as a couple-coloured cow chewing cud, he still fears old Nick will come back if she leaves off her lithium, runs out. It's an amazing thing, kind of many weeks in a mental hospital and more months and years being going to a psychiatric clinic. There was never any attempt to discover what might be the causes. No kind of counselling or just escape brain chemistry, something which is completely unexplorable. Anyway, it was during this process we understood the distinction between legal capacity, which everyone has, and mental capacity, which some of us may occasionally lose for a period of time. We also learned of the proposed capacity legislation. Since I already had made an advanced health directive in London, where in the UK they were recognised in law, hopefully they're now going to be recognised in law here, I decided to add an extra clause related to mental health issues, which I'd never previously experienced. I did this with my lawyer, and my doctor signed a form to say I had full capacity at the time of making this. The extra statement reads, "Any mental health care I require is to centre on rest, counselling and minimal short-term medication, preferably in my own home. In any episode, treatment will assume my recovery and return to normal living. It's an illness and not a condition. I specifically never want to be subjected to ECT again." I included this clause because I am very frightened of further hospitalisation, over-medication. The Mental Health Commission reported that 88% of patients were over-medicated in the hospital at the time I was there. And that, as an older woman, now 77, living alone, I could be further institutionalised, and that was touched on this morning as well. And then, this is my statement. I'm opposed to any capacity legislation where any group of people may have their will and preference expressed in an AHD or elsewhere disregarded. I consider this to be an equality, not a mental health issue. It leaves me and many with similar mental health histories frankly terrified, as we know how damaged previous treatments have left us. Our only option is to keep well. Everyone should be equal under the law. And there is a proposal that if you're committed to a mental health hospital, the psychiatrist can disregard your mental health directive. Sorry, very quickly I'm going to finish now. Because of stigma, it's not easy to say, to publicly admit our mental health episodes, but keeping quiet reinforces stigma and nothing changes. I will now, but always there's a nagging fear that I could go mad. I was going to read a short poem, but I've been telling this time, so thank you very much.
Many thanks, Rosie. That was very powerful and made a very, very important point about the need for advance directives. Our final person is not a Rosie. Liz is going to talk to us now. Liz Brosnan, who we all know.
Hi, well, my role here would be just to sort of respond to kind of frame how the project might be able to contribute to the, how our approach might shed more light on the kind of issues that both Roses have talked about. I think the power that we can see from listening to Rosie here, our poet Rosie, that the lived experience is something that has not been necessarily incorporated into any efforts at law reform before. And when you put somebody's lived experience into on paper and describe it in a way that it brings to light the kind of issues that our academic Rosie was talking about, because Rosie's story highlights all of the complex issues that are incorporated in the area of consent, which we want to illuminate through the interaction between the real lived story and what the law says. And by doing that, our intention is to show and point forward new ideas for how to address these really complex areas in law. But I think it's the stories that are going to bring this legal scholarship to light. And that's the value of, well, we believe that's the value of what voices can offer. The extended period of time that two people who are addressing this area can bring a synergy together, bringing the legal expertise or the scholarship in other areas that have examined the area of consent to, and particularly the issue of refusal, which is such a, as Rosie says, there's such a much higher level of testing functional capacity applied to somebody who refuses medical treatment because of the power imbalances, the issue of coercion, the sort of undue influence, all of the kind of things that are tested when we look at concepts of whether consent is a legitimate, whether it has the power in law to protect people and to make sure that we respect the standards and the new vision that the Convention on Rights of People with Disability challenges to us to reach. So I do think that the marrying the two stories will allow the synergy to shed new light on these complex areas. And so I hope we've given you a taste of the potential to bring these two perspectives together, and that looking at the area of consent to medical treatment will be such an exciting process to be working with the two people who are bringing the two perspectives together. So in order to leave time for questions, I'm going to stop talking.
The most well-behaved panel ever.